This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to speak about insurance contract law. In a typical contract, one party has a duty to perform, construct a building, deliver goods, convey real estate, pay indemnity, and the other party has a duty to pay money. Breach by the performer may take the form of nonperformance, defective performance, or delay in performance. The primary purpose of damages for breach of a contract is to protect the promisee's expectation interest in the promisor's performance. Damages should put the plaintiff in as good a position as if the defendant had fully performed as required by the contract. Damages should never provide a profit to the non-breaching party. Insurance is nothing more than a contract where the insurer promises to defend or indemnify a person known as the insured as a result of a contingent or unknown event that causes damage to the property of the policyholder or injury to a third party caused by the policyholder. Insurance, like all parts of modern society, is subject to the provisions of the law of unintended consequences. In the United States alone, people pay to insurers more than $1.2 trillion in premiums, and insurers pay out in claims as much or more than they take in. Profit margins are small because competition is fierce, and a year's profit can be lost to a single firestorm, earthquake, hurricane, flood, or an unexpected bad faith lawsuit. Neither the courts nor the governmental agencies seem to be aware that in a modern capitalistic society, a healthy and viable insurance industry is a necessity. No person would take the risk of starting a business, buying a home, or driving a car without insurance. The risk of losing everything would be too great. By using insurance to spread the risk among all the costs of taking the risk, to start a business, buy a home, or drive a car becomes possible. The persons insured are dependent on their insurer to take the risks the insureds are not willing to take alone. Insurance contracts can be simple or exceedingly complex depending on the risk taken by the insurer. Regardless, insurance is only a contract, whose terms are agreed to by the parties to the contract, where each make promises upon which the other relies. Over the last few centuries, almost every word and phrase used in insurance contracts have been interpreted and applied by one court or another. Ambiguity in contract language became certain, however, after the states enacted laws requiring insurance policies to be written in language that is easy to read and that all that was necessary to understand was to have a fourth-grade education. In more than 60 years of application across the United States, the tort of bad faith has not, in my opinion, had a salutary effect on the insurance business. Insurance costs more than is reasonable or necessary, so that sufficient funds exist in reserve to pay claims and tort damages from those insureds who believed they were done wrong. Back in 1963, Mr. Justice Harlan dissented from a U.S. Supreme Court decision that did not involve insurance but did involve a party's bad faith and concluded, quote, "I sincerely doubt the wisdom of these guideline decisions. They suffer the danger of pitfalls that usually go with judging in a vacuum. However carefully written, they are apt in their application to carry unintended consequences, which once accomplished are not always easy to repair. Rules respecting matters daily arising in federal courts are ultimately likely to find more solid formulation if left to focused adjudication on a case-by-case basis, or to the normal rule-making processes of the judicial conference, rather than to ex-cathedral pronouncements by this court, which is remote from the arena." This was called Sanders versus United States, and it was a 1963 decision of the U.S. Supreme Court. In Louisiana and Mississippi, for example, multiple millions were paid to settle claims that flood damage was covered as a result of Hurricane Katrina, although the policies clearly and unambiguously excluded flood, and the plaintiff's insureds failed to buy flood insurance. Abuse of insurers has become so rampant and so successful that lawyers obtain multi-million-dollar fees and have even attempted to, or successfully, bribe judges to increase their recovery. Consider, for example, the case of Michael Siegel, the convicted insurance fraudster and racketeer, who appealed for the third time to the Seventh Circuit, hoping that a recent U.S. Supreme Court decision on honest services fraud would give him a new chance to appeal his convictions. In the U.S. of A. versus Michael Siegel, a 2011 decision of the Seventh Circuit, the court gave little to Siegel, recognizing that the great weight of evidence established he was a fraud and a thief, and that any effect of the prosecution's claim of honest services fraud was minimal, and a factual decision that might affect the length of the sentence. Following a trial, a jury found Siegel guilty on all charged accounts, except one that the government dismissed during trial. Subsequently, during post-trial proceedings, the district court knocked out 7 counts. Yet Siegel was sentenced to serve a 121-month term, pay $841,527.96 in restitution, and forfeit $30 million plus his interest in the racketeering enterprise. Not surprisingly, Siegel did not leave detailed records of his crimes. As originally noted by the district court back in 2004, Siegel's lackluster accounting system, which was a deliberate attempt to conceal his fraudulent conduct, precludes such a detailed accounting. On remand, the district court did exactly what the Seventh Circuit asked of it, using the evidence that was available. It cogently explained the amount of money that Siegel took for personal use. None of the shortcomings alleged by the government or Siegel rise to the level of clear error. An attempt by an insurer to investigate the circumstances behind the delay in reporting a claim was found by a New York appellate court to be unnecessary and unreasonable as a matter of law. A position prohibiting such investigation carries with it draconian and unintended consequences. This was Ace Packing versus Campbell Solberg Associates, a 2007 decision of the New York appellate courts. In United States versus Scruggs, an attempt to corrupt Judge Henry Lackey, a Mississippi state judge, in connection with a Hurricane Katrina-related lawsuit titled Jones versus Scruggs. The actors in the scheme included 3 members of the Scruggs law firm: Zach Scruggs, his father Richard Scruggs, and Sidney Backstrom. Also involved were Timothy Balducci, an attorney who worked regularly with the firm, and Stephen Patterson, Balducci's associate, who worked with the firm on various projects and joint ventures, but was not an attorney. The conviction was affirmed. Trial lawyer Richard Dickey Scruggs made millions from lawsuits targeting the asbestos and tobacco industries. He was a part of a network of powerful businessmen and politicians, spanning from Oxford, Mississippi to Washington, D.C., who traded favors, influence, and money. After much litigation, Scruggs agreed to plead guilty on 1 count of conspiracy to bribe Judge Lackey. And when the judge asked Scruggs if he agreed with the prosecutor's account, Scruggs seemed eager to offer a dissent. He said, and I quote, "I joined the conspiracy later in the game. It's not exactly as the prosecutor allocuted, in that there was no intent to bribe the judge. It was an intent to earwig the judge, Judge Lackey." Earwigging is a legal term that is unique to Mississippi. No other state incorporates the term into any code, rule, or statute. Earwigging is intended to prevent an attorney from discussing facts of a case outside of a formal legal proceeding. Basically, it's a prohibition against ex parte communications. The general penalty for earwigging is contempt of court, and the penalty for contempt shall not exceed imprisonment for longer than 30 days and a $100 fine for each offense. So Scruggs was trying to get a shorter and smaller fine and a shorter term in jail. But he did not. Also consider the case where 2 former claims employees at the Hartford admitted taking hundreds of thousands of dollars in payoffs from a Texas lawyer who was charged with trying to buy favorable insurance settlements for clients suing over industry-related health problems. A claim supervisor working for one of the Hartford subsidiaries was responsible for settling claims and recommending appropriate settlement amounts for claims against the Hartford. The indictment against Warren Todd Hefner, 45, alleged that from 2002 to 2004, Hefner paid the 2 claims employees for favorable recommendations on more than $34 million in settlements involving silica-related disabilities. Airborne silica dust in mines, foundries, and other workplaces were known to be able to lead to lung disease. In United States versus Hefner, a Fifth Circuit decision from 2010, the court found that Warren Todd Hefner, an attorney, represented over 900 individuals who brought silicosis and other silica-related claims against manufacturers and sellers of silica containing products and related protective equipment. Among the insurers of these companies was the Hartford Financial Services Group. Hefner, according to the opinion, funded trips for claims people to Laguna Beach, California, New York City, and Palm Beach, Florida. Also, unbeknownst to the Hartford, Hefner paid the claims people approximately $2.6 million and Prestige approximately $760,000 out of the funds he received from the settlements with the Hartford. This case reveals a situation that should concern every insurer, since it revealed the failure of internal security to note two claims people who obtained millions of dollars by paying claims that were not owed. The fraud and bribes caused Hartford to pay more than $34 million in settlement funds, knowing that more than $3 million of those funds would be used to pay bribes and kickbacks to the claims people. So another unintended consequence of good claims handling is crooked claims people. This video was adapted from my book, The Law of Unintended Consequences and the Tort of Bad Faith, a book available as both a Kindle book and a paperback from Amazon.com. If you found this video to be useful or of interest to you and your colleagues, please refer the video to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn of future blog posts and videos. Thank you for your attention.